Ignition sequence starts. 6, 5, 4, 3, 2, 1, 0. Liftoff. We have a liftoff.
Hey everybody, this is the Digital Asset Investor, and I saw Link2 tweet this out, who is one of my sponsors, the IPO roadmap. And I remember looking, I was reading through this and I was like, I wonder where Ripple is on this IPO roadmap. It says 24 to 12 months prior to IPO, create a business plan and equity narratives. 12 to 6 months prior to IPO, appoint internal, external task force. 6 to 4 months prior to IPO, develop prospectus, investor relations. When I saw investor relations, well, I'm trying to remember I think it was it Linda P. Jones that said something about meetings on Wall Street about that were going on, closed door meetings, secret meetings. Oh, said secret meetings. That's a thumbnail. Let me get my pen here. That is a thumbnail for secret IPO meetings. What about that? Okay. All right, we're moving along. But anyway, I want to remind you, the link's in the top of the description for Link2. And today, a birdie told me that Circle will be added to the platform. All right, MicroStrategy, this guy is going to be a mega hero or a mega zero. Okay, there is no in between for Michael Saylor. Bitcoin either survives and he's a rock star, or Bitcoin dies. The government kills it, since we know that they know who Satoshi Nakamoto is and have been pretending that they don't. If it dies, Michael Saylor is up the creek. You will never hear from him again. They've acquired an additional 12,333 Bitcoin for $347 million. As of this, they own 152,333 Bitcoin. eDrag Crypto, we don't often talk about this, but look, he's talking XLM. I'm assuming it's a he. July 2024, $2 or $37. Get ready for XLM revolution. By July 2024, skeptics will be left speechless, just like Cycle 2, And he goes, if XLM follows the same pattern as Cycle 1, we could witness a staggering 58,000% surge during XLM, driving XLM to $37. I hope he's right, because I'm an XLM holder myself. John Deaton did his crypto law show yesterday, and here's an interesting clip about the Ripple test. In this clip, he's talking Supreme Court, those kind of things. I know, look, do you see this right here? I know I follow John Deaton. I've been seeing a lot of things where Twitter is unfollowing me to things. Is anybody else experiencing that?
Let's talk about this concept of anything nefarious going on, okay? That's absolute nonsense from my perspective. Some of you are going to disagree with that, and I can't change what you think. But I will tell you the level of research that needs to be done. Lewis Cohen, the guy that I was talking to, you all should follow him, New York crypto lawyer, a great guy if you follow the spaces today, very bright, knows this case law better than anyone in the industry. And in his research article that we were talking about today, that I made in Exhibit B in the Naomi Brockwell amicus brief I wrote and filed, his brief is 108 article, 180 pages. And I was talking to Lewis, and he joked and he said that, he shortened his article up. So just to read his article and to go through all those cases, okay, that are all in play, 180 cases. Now, when he didn't even go into the Ripple argument in his brief of the pre-1934 investment contract, that issue the judge has to wrestle with. So that means you're talking about reviewing 1920s and 1904 state law cases that talked about this and looking at congressional intent of the 1934 Securities Act. I'm just telling you that the amount of information that this one singular judge has to go over is monumental. And as soon as she gives her decision, it's going on appeal, right? She full rules in favor of the.
Is he saying it's now going on appeal?
SEC. Ripple is ready. I said from the beginning, Ripple's summary judgment brief is written for the appellate courts. And so she knows Ripple's appealing. If she rules in favor of the SEC is most likely going to file a notice of appeal. Maybe they file a notice of appeal and try to negotiate.
I want to say that the people out of Ripple said that the SEC would not appeal. I can't remember where I heard that.
With Ripple and not appeal, but it's going up. Something of this magnitude where, let's face it, this case will go to the U.S. Supreme Court.
I swear I can't remember where, but somewhere I heard that that the SEC will not appeal this. Okay. Prosperity Fund, check this out against that backdrop. He says, breaking XRP Ripple speculation. Ripple case may settle or go to trial instead of appeals court. New court docs show that Clayton Masterman, an appeals expert for Ripple, has left the case. So the guy who's the expert in appeals has left the case. So that's two different things. So we'll see. Now, this is interesting, and everybody keeps saying London's ready. I don't know, well, I guess this clip does make sense. The one over John Deaton, I don't really understand what London being ready had to do with it, but in this one I do. And what Ralph Paul, this is an interesting 2 minutes, because what he's talking about here is historically how countries like the UK or like London benefited in the past from the US or other countries around the world having a stall in their regulations, and they benefited from it. Listen to what he says. This is what's happening right now as a result of Gary Gensler holding up the United States.
The UK says, forget it, we'll do it. It became what's known as the Eurodollar market, which is the overseas market for dollar borrowing and lending. That becomes we don't know the size of it, but let's call it a $400 trillion market. Whoa. And then the US, then we get this big breakthrough in derivatives. The US has got the Chicago Board of Trade doing futures and options and all of this stuff. But we start to figure out more complicated structures, things like swaps. And the US stops its banks doing it by its use of regulatory capital. They're like, no, this is inefficient, you can't do this. The UK and Europe went, well, we're going to regulate and allow it to happen because it's big. We've seen this before. That becomes a quadrillion-dollar market.
Jesus.
That's why every single bank from about 1985, well, particularly after the Big Bang in London, so let's call it from about 1990 to about 2008, 2010, all the major banks' largest operations were London. So Goldman Sachs' biggest operation, most profitable, London. Merrill Lynch, London. Merrill Lynch is different because it was a brokerage firm. But JP Morgan, they were all London. So London, if you've been watching the news, is going to do the same thing. It's called regulatory arbitrage. London is putting together a very sensible set of crypto rules, as has Europe, as has Switzerland, as has Singapore, as has Hong Kong, as has Australia. Okay, there's its old trading group that it did with Eurodollars and it did with derivatives and it did with foreign exchange, all got their regulations in place. The UK is the hub at the middle, and it will capture the lion's share. And before you know it, Coinbase, Gemini, and everybody will move to London.
That makes so much sense for the prosperity of the United States to send all the business offshore and through regulatory arbitrage let them win while we lose. So stupid. What has happened to this country? Arthur Brito, this is a great reminder. Every once in a while, it's a good thing to remind everybody. Arthur Brito, June 2017. The XRP ledger needs to be able to scale to serve 7.5 billion people and even more devices. This reminds me of Mark Phillips' XRP's designed for $10,000 article. Now, for a tweet, I call this the missed tweet. I missed this tweet, but don't you worry, we're going to go over it now. This is something that David Schwartz had tweeted out the other day. I'm going to tell you a completely made up hypothetical story. Okay? Folks, think about Coinbase and when they listed XRP. Any resemblance to real exchanges, living or dead, is entirely coincidental. Imagine an exchange doesn't like XRP despite it obviously being in their business interest. They ask Ripple for millions of dollars to list and we refuse. Months pass, we are at a standstill. They refuse to list, we refuse to pay. They concede they'd list if we didn't exist. In other words, if Ripple didn't, hypothetically, this exchange is letting their ideology enter into the equation. Now this exchange has a problem with Ripple existing hypothetically, but it has no problem with the Ethereum Foundation existing, consensus existing, has no problem with any of that. Remember, hypothetically, of course, Coinbase, many of the people at the time that XRP was listed, even though he's not talking about that particular thing here, there were many people involved that were on those Freedom of Information Act lists. The people that were involved in ETHgate, the Chris Dixons from Andreessen Horowitz, they were on the Coinbase board. Okay? The Katie Hawns, they were on the Coinbase board. Same woman that did the FinCEN settlement with Ripple as assistant U.S. attorney in 2015. Months pass, we're still at a standstill. They refuse to list, we refuse to pay. They concede they'd list if we didn't exist, even though they have no problem with the Ethereum Foundation or consensus existing. To the outside world, the refusal to list appears inexplicable. Finally, Ripple works out a deal where we give the exchange money and they list XRP. XRP immediately becomes 20% of the exchange's revenue. We are pissed, but what else could we have done? Had we not existed, the exchange would have listed months ago. We paid money to not let our existence hurt the ecosystem. Then a litigation adversary selectively uses some of these facts to imply we were using money to unfairly boost XRP adoption or liquidity. If that actually happened to you, would you be pissed off? Almost as if the SEC used this very thing against Ripple. Of course, he's not talking about that here, right? I'm the digital asset investor. I'm not an investment advisor. This is for entertainment purposes only. Please subscribe, hit the like button, and tell your friends and family about the missed tweet. Thanks for listening.